Senior counsel for the appellant.
May it please the court, my name is Hobbs. On behalf of the appellant, I appear with my learned junior, Mr. Kelly, and we should be speaking for approximately 15 minutes apiece.
My advice to students would be, first and foremost, after you've done all your preparation and on the big day are standing at that lectern facing the judge, take a deep breath in before you begin your submissions. The second really important piece of advice is to try and have a conversation with the judge as opposed to just making a speech. It's really important that you make eye contact and sort of feel about to see how the judge is responding to your arguments and to where you need to go with your legal arguments.
Senior counsel for the respondent.
May it please the court, Your Honour. Gorry and Berryman, the respondent. It's a good idea to be very clear about your structure of your submissions. I think a good idea is to sit down to begin with and figure out what the issues in dispute are, and then really think about the elements that you need to prove in your dispute. For instance, in a criminal matter, you obviously have the elements of the offence, which include the mens rea, the actus reus and those sorts of things in a general sort of criminal offence. I think it's a good idea to sit down and be very clear on every element you need to prove your case. And then when you make your submissions, to have a very simple structure and try not to run into alternatives and those sorts of things, and really just put your best point on each of those elements so that you can establish them all. And then at the end of the day, you can make your point on appeal, or you can make your point at first instance, and you can win the moot.
Like any problem in law, the very first step should be to read through the problem and identify the issues. What questions of law arise? Focus on the facts. How do the facts apply to the questions of law? So it really is like an essay, it's like practice, where there's a process of reading, understanding the problem before you, and then identifying the issues. That's always got to be the first step.
When you first get the moot problem, it's a good idea to read it through. If you don't know the area of the law at all, it's a good idea to start with the reading list if they give you one, and go through that before you start picking out the important things in the problem.
I think the first thing you should probably do is read it very closely and try and get an intuitive feel for any arguments you think might be placed, not just for the side you're arguing, but also for the other side. And once you've got that structure in your head, then you can start to research the preliminary authorities about the matter and start to build a structured argument in your head that you think will run well on the moot.
Read the problem carefully. Read it a number of times and make sure you understand it. And the best way to do that is to write your own draft of the problem so that you have everything clear in your mind and it's all made very simple. Often the problem will be convoluted and some of the facts won't be in the proper order. If you put them in the right order and in your own words, you'll be able to understand it. Of course, the next stage is to understand the law very well, and if you understand both of those things to the best of your ability, you'll then be able to put together some very tight arguments which will possibly, if you argue them well on the day, give you the win.
There are a few. You have to be careful that you don't get caught in circularities of argument. You've got to be careful that you don't get caught up with spending time on issues that ultimately are going to be irrelevant. So you've got to identify what the major issues are. However, at the same time, you've got to be prepared for questions from the bench and arguments from opposing teams that raise issues that you might, at first instance, have thought were irrelevant. But once you're faced with a question from the bench or an argument from your opposing team, you have to be prepared to respond to those. So on the one hand, you've got to be careful that you don't get carried away with trivialities and irrelevancies. But at the same time, you've got to be prepared for questions from the bench and arguments put up by your opponents.
Speaking too quickly not speaking clearly enough. You might have a tendency to use large, long words. It's not really necessary. However, you need to be careful to avoid colloquialisms, even if at times, particularly because in a university sort of a moot, you may have a judge that's a grad student. They may use colloquialisms to you. It's still not appropriate for you to take those on board. You still need to remain formal. It's still a court setting.
Not reading enough. If you read the relevant cases and you understand them well, you'll have a good grounding to deal with the questions which you will be faced with. If you don't do that and attempt to wing it, you may detract from the legitimacy of what you say. In fact, being able to weather questioning is one of the greatest skills, and if you're able to get that down early, you'll be able to do quite well. So if you are able to handle the questions by being confident and by being able to put out a decent amount of knowledge in a simple way, you'll be able to get through. The biggest mistake is to overcomplicate things under questioning. If you keep things simple, you'll be successful.
May it please the court, Your Honour. The appellants put two submissions in this appeal. Firstly, that the telex became effective upon dispatch, and secondly, that a letter of rejection will only take effect upon arrival. To this, the respondent. First-time mooters and guys who haven't mooted a lot often speak too fast. Also, it's very common to get too hung up on the law when really in moots and in cases generally, a lot of things turn on the different facts in different cases rather than a question from a judge where they say, you know, why should we do X in this case? And students tend to answer with cases. A good idea is to obviously know the cases back to front, but also you need to get across the facts in your dispute and really decide why your case should be decided differently to the decision of first instance if you moot an appeal, or why your client should win if it's a first instance moot.
I think really the first thing that students should do is understand that they're not only in a competition to put forward their arguments, but there will be questions from the bench and there will be a need to respond to your opponents. So to a degree you've got to be able to preempt what issues, what questions will arise. One of the problems I've found both when I was a mooter and also in coaching teams now is that students don't prepare for questions from the bench. Those that don't prepare will often try and bluff their way through, and really that there's nothing that should be avoided more than that. Nothing looks worse than trying to argue your way through a point that you have no idea of. If you're asked a question by the bench and you don't know the answer, be upfront about it. Tell the court that you're unable to assist them with that issue and then move on. Whilst there is a need to have some degree of order in your arguments, you've also got to be prepared to break away from that. So if you've got a script and have prepared yourself for going into the moot and running through that script, you have to be able to break your line of thought if a question from the bench arises. And some moot competitions go through with very few questions being asked. Other competitions you'll find that of the time allocated for speaking, 90% of that is taken up in answering questions from the bench. So you've got to be prepared to change tack and not just stick to a prepared script.
I guess don't be too nervous. I mean, if you're a first-time mooter, the judge is going to be aware of that. They'll probably take it a little easier on you. But nevertheless, just be very well prepared. So preparation will give you confidence.
Be calm. Remember that there is a big gulf between the bench and the bar table. That is to say, The judge has come at this having only read the problem maybe a few hours prior or even a few moments prior. You, however, will have been reading the thing for a week and you'll have a good grasp of the law. Therefore, if you make things very simple and keep things very calm, you'll be able to teach the judge almost what he needs to know. And if he trusts you, and if you're able to convince him that you are the one with the law on your side, what you then argue will become very convincing. So if you are calm and knowledgeable, you will succeed.